The inheritance laws in California mirror what I think most people would expect to happen to their assets. So if somebody did not have a will and they died and they have assets that need to get passed on, the law says that it goes to potentially a surviving spouse, if that person had a spouse, depending on the character of the property. And then also next to the children of that decedent and any grandchildren of a predeceased child. If they did not have any children or grandchildren, then it would go to the parents of that decedent. If their parents were not living, it would go to the siblings of that decedent. If their siblings were not living, then it would go to their nieces and nephews of that decedent. If they did not have any nieces and nephews living, then it would go to their next of kin, which would go out to cousins or second cousins and so on. Typically, there is an heir that exists somewhere for every decedent who passes away that the assets should transfer to. So in California, most likely there will be an heir that exists that will be entitled to receive the assets of a decedent who died without a will saying where they would go or a trust saying where they would go.